You said what time is it? What time you said is that? Is that what time?
All right, this is case number 21-152348. This is Coolidge Imaging LLC versus City of Detroit. The matter is before the court. I have it noted as a review date. Your appearance for Coolidge Imaging, anyone here from Coolidge Imaging say something at this time? I do see Mr. Asher here. Your appearance at this time, sir.
Good morning, Your Honor. Alfred Asher on behalf of defendant, City of Detroit, P82536.
All right, thank you, Mr. Asher. Good morning to you, sir. You've been in contact with counsel on the Coolidge matter?
Yes, Your Honor. We did settle the case. I believe last time we were waiting for approval from City Council. We've obtained that approval. At this point, it's just a paperwork matter between the two parties, but the case is resolved.
All right, very well. I will note then that the case is in fact resolved, and we will await the order in that regard. And thank you, Mr. Asher. Good day to you, sir.
Thank you, and have a happy Thanksgiving to you and your staff. Thank you.
All right, this is case number 21-49753. This is HS Financial Group LLC versus Michael Gregory. The matter is before the court, set on for a subpoena relative to request for documents post judgment in this matter. For the plaintiff, HS Financial Group, please. Mr. Holzman, I see your indication there. Are you able to hear me at this time, sir? All right, do I have Michael Gregory on this Zoom? All right, I'll come back to that matter. I do see Mr. Holzman has indicated, but has not responded at this point.
Your Honor, I don't believe this is my file, and I'm having trouble getting my video connected at the moment.
Is that right? Thank you, sir. It looks like, it looks like I'm seeing somebody else now too. Thank you. I appreciate it.
Not a problem. I'll be joining back in momentarily.
Not a problem, sir. All right, this is case number 19-149696. This is Midland Funding LLC versus Teresa Randolph. The matter is before the court on the following objections to a writ of garnishment. The record should reflect in this matter that a judgment was entered in this case on the 14th of May of 2019 for $1,126. And it is that judgment that the plaintiff seeks to collect on, and the objections are filed to the writ of garnishment in that regard. All right, your appearance for Midland at this time? For Midland Funding? All right, do I have Teresa Randolph on the Zoom?
Yes, I'm here. Good morning.
Good morning, Ms. Randolph. Ms. Randolph, there was a writ of garnishment filed, of course, in regard to the judgment that was entered that I've been talking about. And I do have your document that you filed objecting. You indicate under F, you were not given any notice to dispute the validity of this claim. That does not set forth a valid objection to the judgment in this matter. You would have to file something attacking the judgment in the way of perhaps a motion to set aside a default judgment. But at this point, that would not be a valid objection. All right. Do I have someone from Midland on this one? All right. So anything else you wanted to bring to my attention at this time, Ms. Randolph?
Yes, I would like actually filed the objection because I don't agree with the amount that they are saying that I owe. The credit card was for only $500, and I did miss a few payments, but I continued to make payments on it. They ended up closing the account, and I had no idea they were going to close it, even though I was continuously making payments on it. So after the account was closed, they still continued to add on fees, interest fees on a closed account, and that's what I don't agree with. It was a $500 credit card, and I don't have an issue with paying the $500 that I initially, the card was when I initially opened it. I don't have an issue with that. The issue that I have is that they continue to add on fees and interest fees on top of a closed account. If I can't, I'm sorry.
Let me stop you for a moment. It's a little bit of a struggle here. It sounds like there's another device in the background or something. Because your sound keeps chopping up. Do you have two devices or something, a phone and a computer that you're using?
No, I don't.
Okay.
Just the laptop.
Okay. You sounded better then.
Can you hear me?
Yeah, I can hear you, but you were breaking up. Let me try to get that sound up because. Okay. I heard you at the beginning, but then there was a dropout.
Okay.
And the last few statements that you were making, ma'am, is what I did not hear. Go ahead, ma'am.
Okay, I basically was saying that credit card was $500. They ended up closing the account, even though I was continuing to still making payments on the card. I didn't know that they were going to close the account. But my issue was that they were still putting on fees, late fees, interest fees on a closed account. I feel like if I can't charge on the card, why are they still adding on fees and late fees on top of a closed account? I don't have an issue paying $500 that I had when I initially opened the account, but to continuously add on late fees and interest fees on top of a closed account, I don't agree with, sir. And I didn't even get a notice as far as a hearing for when they received the judgment. I would have been there to object to this, and then on top of that, they want to add on over $800 in attorney's fees. I don't agree with that as well.
Thank you, ma'am. All right, the number one issue that you have here is that what you're doing is you're filing an objection to the garnishment, and then you're attacking the underlying judgment. You can't do it that way. If you believe that the judgment should not be entered, or that is the inaccurate amount, and you have compelling reasons to believe that the judgment should be set aside, you have the right under law to file a motion in that regard. When you file objections to a writ of garnishment, the objections have to be something that sounds like, I've already paid it, I filed bankruptcy, I'm already under installment order, something along those lines. And that's because we're already past that stage where the judgment has been entered. So none of the reasons that you've given are a valid reason to object to the garnishment. You may very well be able to file a motion if you wish to do so and address those issues under trying to attack the judgment. What happened is, in this case, just a brief synopsis. In this case, of course, a complaint was filed. When that complaint was filed, there's a process served that signed the affidavit indicating that they served the document on you on the 3rd of April of 2019. That was served on you at an address on North Lawn Street in the city of Detroit. The filing of that affidavit of service then brought the matter before the court. You had 21 days after that document was served. You had 21 days to file something in response to that. And when nothing was filed, that's why the judgment was entered by default. And ultimately, that's why a default was entered, and ultimately a default judgment. So in order to deal with any of that, you would have to file a motion to set default aside and try to persuade the court that the affidavit of service is inaccurate. And moreover, you would have to be able to raise before the court what's called a meritorious defense. Meritorious defense is being able to establish that the debt is not yours, that somehow you have a defense to the claim. But that's a separate kind of thing. Right now, there is a judgment against you. Because there is a judgment against you, the plaintiff has the right to collect on that judgment, and that's what this writ of garnishment is all about. So this garnishment, does this to income tax return, or does this relate to some winnings? What does this garnishment relate to?
Credit card, sir.
The garnishment is on a, I'm sorry.
It's on a credit card.
All right, so you have a credit card with the state of Michigan that was garnished?
No, it was an income tax that they took.
Oh, that's the question that I'm asking you. And how much is the income tax return?
What they took, you want to know exactly what they took, the amount?
Yeah, I want to know what was intercepted in the state of Michigan.
Exactly. Here it is. 1,000. What's it? 1,000.
All right.
$1,155.25.
All right. $1,165.25. All right. So that amount is right at the amount of the judgment in this matter, and so they're entitled to garnish at that amount. Now, so I will deny the objections to the garnishment. What you have the right to do is to file a motion to set aside default or something along those lines. And if you're able to establish that the judgment should not have been issued against you, you would to refund of your money. But you have to bring a separate kind of case or separate kind of objection to be able to address that issue. You understand?
Okay, so when I go to file an objection, it should be, what should the objection?
No, I need you to hear me clearly. You filed objections. Objections. The objections are invalid. You don't have a statutory or valid objection to file. There is a valid judgment entered, and your objection to the garnishment would have to be something like, I already paid, I filed for payment. I'm under a partial payment order. That would be the way that you would object to garnishment. I don't think that you have any way of really objecting to the garnishment based on the things you told. What you seem to be doing is attacking the underlying judgment, saying that that I wasn't served, that the amount is more than what I should have to pay, et cetera, et cetera. You would have to file a motion to try to get that judgment set aside. That's the only way that after that. And if you can get the judgment set aside, then anything that happened here today will be undone. But if you can't get that judgment set aside, then the money that is being released to the plaintiff today would satisfy the judgment. That should be the end of it, and you wouldn't have any other further ongoing obligation. But if you were able to get it set aside, you would get the money back, and then the case would go forward accordingly. Right?
Okay.
So my order is going to deny the objections to the writ of garnishment. That will release the money to the plaintiff in this case. The things that you raised, you could put them in a motion to set aside the default judgment and ask the court to set that aside. There's no guarantee that will happen, but you can file that, and that will have to be reviewed if you file it with the court. Right? That is my order today. I do wish you, and you'll receive a copy of the written order from the court in the mail shortly. Thank you.
How long do I have to file this?
You can file your motion. You can file a motion to set aside the default judgment at any time. The problem is the longer of a delay it is, the less likely it is going to be that you set aside. And it's already been like, you already passed more than 2 years since the entry of judgment, approximately 3 years back with the case itself. Well, actually, the case was filed sometime in 2019. So the judgment was entered in 2019 as well. So it's already been a couple of years on this. And that document is saying that it was personally served on you. There's a process server that signed an affidavit saying that they personally served. So you got a mountain of clock, but that's all you got left is to try and get it satisfied. So and you can do that at any time. At any time. All right. So I wish you well and
Thank
good day
you.
to-
Thank you. You too.
All right, this is case number. Case number 16-116229. This is Michigan Schools and Government versus Leon Calloway and Kawana Needs. The matters before the court on the filing of objection for writ of garnishment. The record should reflect in this matter that a garnishment did issue in this matter apparently on or about the 5th of November is what I think I'm seeing here. The judgment in this matter was entered based upon personal service and a failure to respond. That judgment looks like it was entered on the 4th of November of 2016. All right, your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Wesley Neal on behalf of plaintiff P number 80307.
All right, thank you, Mr. Neal, and good morning to you. Do I have Leon Calloway or Kawana Needs on this one? Say something if you're here.
Yes, Kawana Nieves.
All right, thank you, Ms. Neves. And I see the objections to the writ of garnishment that you filed. You indicated that you have an installment payment plan in place and that you've been keeping up with the installment. Is that correct, ma'am?
Yes.
All right. The challenge here is that this is a different type of garnishment, and the existence of an installment payment does not prevent garnishments, I should indicate, bank accounts or state income tax returns or state agencies. It only prevents other wage type garnishments, and that seems to be the challenge here. So I see that third party withholding, state of Michigan, is that an income tax return or does that relate to lottery winnings, or what is that coming from the state?
Yes, I believe they're trying to take the state income tax return.
Yeah, do you know how much money is there with the state income tax, ma'am?
Normally it's probably like a few $100s.
Yeah. All right, so there are two separate type of garnishments. One's a non-periodic, another is a periodic garnishment. And so you have two types of situations going on. One, you stop the wage type garnishment because you have a partial payment order in place. But that does not stop garnishments like a income tax return or garnishments that relate to bank accounts. Let me hear from Mr. Neal on this matter, sir.
Just as the court has said, Your Honor, this objection to state of Michigan income tax garnishment, one, we've not received anything. I don't believe the defendants filed their taxes as of yet. So I have no idea if any funds have been withheld at this time. And as the court has said, the existence of any installment payment order that we do have, and even if the defendant was making timely payments on this, does not preclude garnishments of the type that we're having an objection on, that being a non-periodic garnishment to the state of Michigan Treasury.
Right. Yeah, that's a problem here, Ms. And I'm trying to say the name right, Davis. Tell me, anything else you, wanted to tell me about this matter? Because
So
that's
I'm
a
not
cha-
really, so this can just come about just because, like, even though we've been keeping up with the installment payments?
Yeah, it's a different type of garnishment, and that's, it's a non-periodic. The installment payments is a periodic garnishment. Now, unless, the parties have an agreement that, making the partial payments, will also, that the plaintiff will not proceed against, other types of garnishments. You'd have to have a separate agreement in that regard.
I believe that was in the agreement. As long as we have not missed a payment, they would not garnish us. I believe that was in the first court agreement.
Yeah, that's that, and I don't have a complete file here, but that it would not garnish your wages. That's what that's talking about. That's garnishing your, that does not relate to a totally different type of garnishment. And that totally different type of garnishment is called a non-periodic garnishment. That's a garnishment of bank accounts, garnishment of things like income tax return, et cetera. And that's what's happening here. And it probably has something to do with the fact that the judgment in this case is substantial. I see that the agreement calls for a monthly payment of $100 per month, and that the judgment in this matter is approximately $10,000. So
it went down to like 4,000.
yeah, you have, and that's because of payments, and that's a substantial amount that yet remains, and that's why the plaintiff would be looking for other avenues to try and collect on it. I don't know if Mr. Neal, on behalf of his client, is in a position today to say that they would enter into a further agreement that in the future they would not garnish things like bank accounts and income tax returns in light of the partial payment. What the partial payment does is it stops the wage garnishment. That's a totally different type of garnishment. And the law allows wage garnishment, and then it allows separate kinds of garnishment. But when you do a partial payment, that partial payment stops that wage garnishment. So you're paying $100 a month. Technically speaking, if they were able to do the wage garnishment, they could be collecting $300 or $400 or $500 a month. Unfortunately, it's not current, but that does not stop the other garnishment unless there is a written document that establishes that. Mr. Neal?
Your Honor, I just had a chance to review the file where the court was speaking with the defendant. There's no agreement in the file that states that we will not proceed with state of Michigan tax garnishments. There's agreements regarding the precluding of wage garnishments as long as there's timely payments, but nothing on any third-party Michigan income tax garnishments.
Okay.
Yeah,
So,
go ahead, Ms. Davis, before I make my ruling, ma'am.
so there's no way really to stop this from happening at all.
Unless there is an agreement in that regard. You stop the wage garnishment. They're key as long as you're making those payments. But it doesn't stop the potential for garnishments against state income tax current return. Of course, you can't garnish federal returns. And it doesn't stop things like garnishment against bank accounts. It doesn't stop those.
Okay, so, okay. And you said they can garnish like the federal too?
No, the federal cannot be garnished.
Okay, okay.
All right. So, ma'am, I'm going to be deny the objections on for the reasons that I've indicated to you on the record. You made great progress on this, and I know that additional dip sounds like it's something that is just adding insult to injury, but the law allows it, and that's the only thing that I would allow it to go forward at this time. So I will release funds held by the state to the plaintiff, and that is to be applied to towards the judgment. So whatever balance is, that balance should go down based upon that, the application of those funds as well. Right? I do wish you well. Good day to you, ma'am. Thank you, counsel.
Thank you.
Thank you, Honor. You have a good morning.
All right, this is case number This is case number 21-47204. This is Second Round Subs LLC versus L'Oreal Johnson. The matter is before the court on the following objections to a writ of garnishment. That garnishment arises out of the entry of a judgment in this matter. That judgment appears to have been entered on the 16th of September 2020. The judgment amount on entry was $1,264.83. Your appearance for a second round, please.
Good morning, Your Honor. Mimi Kalish, P number 52383 on behalf of second round.
All right, thank you, Ms. Kalish. And good morning to you. I'm looking now for L'Oreal Johnson. Ms. Johnson, if you're on the Zoom, please say something at this time. L'Oreal Johnson. The record should reflect that the matter is set on for, looks like it's a 10 o'clock call. Let's make sure. Yeah, set on for 10 o'clock. It's now 10:18. Again, the court in this matter is looking for L'Oreal Johnson, a person occupying property on Manor Street in the city of Detroit. If you're on this Zoom, anyone representing that person, please say something at this time. It does appear now that the defendant has not appeared with respect to the objections on the writ of garnishment. The objection stated that the maximum amount permitted by law is already being withheld by another court order. And the defendant has not, however, appeared on the objection as she is required to do so. Accordingly, the court will find the objections invalid at this time for releasing the withheld funds to the plaintiff. That will be the order of the court in this regard. Thank you, Madam Counsel.
Thank you, Your Honor. And to the extent that Ms. Johnson refiles this objection and plans to appear the next time, I would like the court to reserve the issue of assessing costs for her failure to appear.
Well, you certainly can bring that up at a future time, but it is what it is. It's a person under a bunch of stuff. She claims she's already maxed out on judgments. That's probably why she didn't show up. But we'll, you can certainly raise that when you come in front of me again if she files the motion.
Understood. Thank you, Your Honor. Thank you. Have a safe and happy holiday.
Likewise to you, ma'am. This case number 21-55440. This is Michigan First Credit Union versus Lena Thomas. The matter is before the court regarding objections to a writ of garnishment. Looks like there is also the filing of a petition for partial payments. The writ of garnishment is occasioned by the entry of a consent judgment on the looks like the 7th of January 2021. The judgment on entry is set, the amount is $9,940.50. Your appearance for Michigan First, please.
Good morning, Your Honor. Daniel Holzman, 82344 on behalf of the plaintiff.
All right, thank you, Mr. Holzman, and good morning to you. I am looking for Lena Thompson. Oh, yes, Lena Thomas. Lena Thomas, person living on Santa Barbara Street in Detroit. Also having some connection to Diversified Credit Union. If you're on this Zoom, please say at this time. The record should reflect regarding this matter that it is set on for 10 o'clock a.m. It is now 10:21. It does not appear that Ms. Thomas has appeared for the objection or for hearing on the petition for partial payments. She has asked of the court that she be allowed to make payments of $50 per month. Counsel, anything at this point, sir?
Your Honor, as to the objection garnishment, the garnishment that she is objecting to is a bank garnishment. I believe the issue really is moot, as the financial institution in which the garnishment was served on indicated that This defendant does not have an account with them. So I guess that's really a non-issue. As for the motion for installment payments, as we indicated in our response, $50 a month we don't feel is reasonable and are requesting a higher amount. But due to the defendant's failure to appear today, I would respectfully request the court deny her motion.
All right, thank you, Counsel. With regard to the the objection to writ of garnishment, I'm going to find that the issue is moved where there are no funds available, and that the garnishment would be set aside on that basis. If there were any funds, they would be released to the defendant. In regard to the petition for partial payment, I do see that the defendant has indicated employment with the Detroit Public School System. It's saying, so there does seem to be some employment and perhaps some ability to pay, but the amount that she's indicated is obviously not a reasonable amount in light of the amount of the judgment. The judgment is like some $9,000. What I'm going to do is I am going to give the defendant an opportunity. I'll set the installment payment at $125 per month, $125 per month, and I'll have that installment commencing on January 7, 2022. And of course, if the defendant makes the payments, then that will solve the issue as it relates to potential wage garnishments. If not, then the court would set the order aside and allow for wage garnishment.
Your Honor, just for my clarification, I believe your sound was breaking up when you were indicating the dollar amount. Can you please verify what that dollar amount per month is?
$125 per month. And I'm commencing that on 1/7. All right, thank you, counsel.
Thank you, Your Honor. Have a happy Thanksgiving to you and your staff.
Likewise, sir. Thank you. The court now calls case number 21-148200. This is Cambridge Auto Finance LLC versus Alicia Price. The matter is before the court on the following objections to a writ of garnishment. This is in regard to the state of Michigan. This is occasioned by the entry of default judgment on the looks like the 21st of April of 2021. That judgment amount on entry is $6,251.78. Counsel, your appearance for Cambridge.
Yeah, good morning, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
All right, thank you, counsel, and good morning to you, sir. I'm looking now for Miss Alicia Price, a person living on Terrell Street in Detroit. Ms. Price, if you are on this Zoom, please say something at this time, ma'am. Again, the court is looking for Miss Alicia Price. The record should reflect this matter was set on for 10 o'clock this morning. The record would further reflect that that it is now 10:26 a.m. It looks like Ms. Price has not appeared in this matter. Looking at the objections to the writ of garnishment provided, the writ is not properly issued because it says, served to me after my time to file the motion received November 5th from September 16th, the date of the file. That statement would not constitute a valid objection. And I don't see anything else that has been offered by the defendant in regard to the writ of garnishment. Counsel, anything at this time, sir?
Just that we've not been in contact with the defendant in this case, and we agree with the court. We don't, at best, perhaps she's attacking the underlying judgment or potentially the service of the garnishment itself. But in either case, it's not a valid objection. We'd ask the court to deny it on that basis and on the basis she's not come forth to advance her own motion.
All right, I will deny the objections, find them invalid on their face. And obviously, that is complicated by the fact that the defendant did not appear on her objections to explain further to the court what her basis might be. Accordingly, again, the objections are found to be invalid. All funds are released to the plaintiff. I'm signing the order consistent there with that at this time. Thank you, Counsel.
Very good. Thank you, Your Honor. Have a nice holiday.
Likewise, sir.
Thank you.
All right, the court calls case number 21-159-451. This is Unique Lab Solutions versus City of Detroit. The matter is before the court, set on for a pretrial conference. For Unique, your appearance at this time, please.
Good morning, Your Honor. Mark Gozer for the plaintiff, Unique Labs, P number 79070.
All right, thank you, counsel. Good morning to you, and for the City of Detroit, there, your appearance, Madam Counsel.
Good morning, Your Honor. Crystal Olmstead on behalf of the City of Detroit, P69202.
Good morning to you, Ms. Olmstead, and happy holidays to all. So I put a bit of a schedule on this and set it up for hearing on today's date to see where things are. So head and update me, somebody.
We actually talked this morning and have resolved the case.
Really now? Okay, well, all right, let's get to the Thanksgiving preparations early, Dan.
Right.
Is that about the size of things, Ms. Olmstead?
Yes, Your Honor. Of course, pending City Council approval, and they're on recess at this time, and we'll be back in early January.
All right. Now I have an order that you probably received from me before. It's an order of conditional dismissal, and it specifically states that the settlement is pending City Council approval and dispersal of funds, and that there's an automatic reinstatement of the case if those two contingencies do not occur. My intent would be to issue such an order.
Your Honor, I'm sorry, I didn't hear that very last part of it.
My intent would be to issue such an order. Ms. Olmstead.
That's perfect.
Yep, works for us.
You'll get something from me in the mail in short order. And again, I trust that it'll all work out. So if not, then it would just be reported and I'll put it back on the document. All right. Good day to you, to the two of you. All right. Get some rest. Do something. And don't eat too much.
Thank you, Your Honor. I'll try not to. Happy Thanksgiving, everyone.
Try. Yes, all right. All right. All the best.
Bye-bye.
All right. Mr. Weberman, are you on the HS financial matter?
I am. I was just checking in to say that we didn't serve it. So I was hoping I was told to ask for a new date. But I don't know if I can just get a new date or if I have to resubmit the subpoena.
All right. I will go ahead and send it over for a new date. And that's I can. Yeah, if you want to, let's just do it on maybe the 15th of December.
I'm just thinking, I just don't know if they had trouble serving it. So if further, like maybe even the next year, I could try to serve it or something.
All right. So let's put it then for the 6th of January, 1/6 at 9:30.
Will the court send out a updated subpoena, or do I need to submit anything?
if you would, if you could, email something over to me, so, as you know, most of the stuff is written in, so if you will email that subpoena over without, you know, my handwritten notes in it, I can change.
What's the email address I should have it sent to?
Yes, sir, that's Latifah, LATIFAH, at, Latifah.Hunter@36districtcourt.org.
All right, I will have it sent over. Thank you very much, Ron.
Thank you, sir. We'll get that right away. I'll be ready. All right, look like I have someone from Midland here. Did I call you already? Counsel, which case did you have?
I'm here on Midland Funding versus Teresa Randolph.
Oh, you're what they call late.
I don't know, they assigned me the wrong Zoom number. I called the court to find out. They sent me to Judge Giles' courtroom, and I logged in at about 10:03. Okay.
Well, it's always much better to be here. Anyway, on that particular case, the objections to Ms. Randolph did appear. The objections to the writ of garnishment were denied because she didn't state a valid reason, and the reasons that she did set forth were aimed towards trying to undo the judgment. She said she had not been served, and she said that the amount was inaccurate. So I told her that she would need to file something attacking the judgment. So the writ of garnishment, the objections to the writ of garnishment was denied. And I understand that the amount with the state was in the nature of $1,100 that would be applied towards the judgment.
Yes, sir.
She says she's going to file a motion. We'll pass it when we get to it, but that was the outcome of the case on the objections today, sir.
Okay, I apologize for the confusion. I had to call the court clerk to find out where the case was actually assigned. I appeared in the wrong courtroom and waited there, you know, and
we're having some of those kinds of challenges, but I don't know, you know, when I know it's, you practice all over the place, but if you can remember, mine is 336. So if you hear anything that's got Judge Coleman on it, you know, 336 will get you to me, because they finally set up.
Right, you know, they just gave me a Zoom thing with Judge Giles' courtroom, and I'm sitting like an idiot in that courtroom. And I finally asked the clerk, "Do you have it up?" And he goes, "Oh no, that's Judge Coleman." I said, "Please, what is the Zoom?" I got there at 10:03 and must have already called it. So
Yeah, and see, that's my court officer. Typically, when folks are coming in, he'll ask, you know, just to try to line it up, because you know, you get one of these civil ones, and the judge is sitting there hearing a bunch of civil cases, one after the other. You quite naturally figure that yours is coming up, but you know, you know, that could be fool's gold, you know. You know, before you know it, time has gotten by. So we're working on it, and you know, as best as you can, you know, check in and try to get some information once you come in.
right. I think the error may have been on our part. Okay, when they assigned me this thing, they just gave me the default number for Judge Giles today. You know, so I know your number is 336, but he didn't tell me it was your case. So
right. That wouldn't help you much under those circumstances. All right.
Yeah. But anyway, thank you for denying it.
Yeah. Well, it was pretty straightforward. It was you know, it was kind of tough to look at, because she felt that she had a basis. I think that she had either a husband or somebody there that was with her. But the case was
But this was a personal service case. I mean, they were aware of it. They got personally served on it. The judgment was entered, and so there really wasn't much basis for it. This was on an account that was open for 2 years on a credit card. You know, So,
That was, that, and all of those things was what I put on the record, because I went back at the proof of service to see, you know, what she was saying, and the proof of service had personal service, with an affidavit. And
Right.
the description seemed to fit her, but I told her that's a fight for another day if she wanted to try that. She also said that the account was closed and they kept charging interest. I said, well, you know, that the contract governs a lot of that. So, you know, but if she wanted to raise that, I told her she had the right to file a motion to do so.
okay. Well, anyway, you have a great Thanksgiving and thank you.
All right, all the best.
Okay, have a good one. Okay, thanks.